do you think we should do more cold opens?
More cold opens?
Yeah, more cold opens.
Like
All
this,
right.
a meta
Yes.
cold open.
Yeah, we love a
Sort of
meta cold open.
doing cold opens about cold opens. Uh, Catherine, you should start anytime.
Hello, everyone. Um, okay, just letting people trickle in. Cold open, cold open,
Frigid.
frigid open.
That's colder than the courthouse, which after additional complaints has been somewhat sticky.
Yeah, I heard it's not that cold.
Yeah, Quinta, you arrived just in time because it was freezing. I mean, I kept like being like, I'm gonna get hypothermia, and this was like last week. So you came at the right time.
I brought a big heavy sweater, as you can attest.
You did.
And lugged it around pointlessly for the rest of the day.
On that note, hello all. Welcome to another live recording of Trump's Trials and Tribulations, New York Trial Dispatch. Today is May 21st, 2024. I'm Catherine Pompilio, Associate Editor of Lawfare. Today I'm joined by courts correspondent and legal fellow Anna Bauer, Managing Editor Tyler McBrien, Senior Editor Quinta Jurecic, and Editor-in-Chief Benjamin Wittes. Hi, everybody. Welcome. Let's get started with some color. How was the early line today? Do we need to shout out the line dudes?
We definitely need to shout the line dudes. I also will say to everyone that I met their rivals, the man who holds a grudge against the line dudes. He calls himself the parking pirate. And he apparently holds parking spots for people in a Bushwick garage or something like that. And he, had many grievances against the line dudes, but as an organization that has used the line dudes and the line dudes have saved us from many sleepless nights during the Trump trial, I'm still very pro line dude, even after hearing the airing of the grievances from the parking pirate.
I'll also give a shout out to the member of the public who I met who is very much not using the line dudes. He lined up Sunday night in order to get into the courtroom this morning, which means he spent 2 nights in the park, and he made it in.
Oh,
And
good
then
for him.
I assume slept through the entire proceeding or not.
Yeah.
So what was going on in the courtroom? I heard Trump had quite a big entourage who was there today.
He did. He had probably one of his biggest yet. It took quite a bit of time for them all to file in and find their seats. I was in the courtroom this morning, and Trump, as always, was in the pole position. And as he walked in, he greeted Andrea Mitchell and had a few words for her. And I was right in front of him, though, and I couldn't actually make out what he was saying. But it was I think some new faces. I believe Sebastian Gorka was a new face today. He was holding this metal briefcase with the presidential seal on it. We saw a few familiar faces. We saw a few members of Congress. Don Jr. was there as well. We've seen Eric Trump a few times, but we haven't seen Don Jr., I believe. I believe this was the first time. And so, yes, it was quite a large delegation this time.
And I just want to point out that Chuck Zito was back
He's back
with both of his pinky rings.
Super Bowl sized pinky rings. Okay, so we had our final witness today, Robert Costello. As we saw with the release of yesterday's transcript, there was a bit of an explosive back and forth between Merchan and Costello. Did anything like that happen today? Or was it clear waters?
It was pretty peaceful. Costello was mostly on good behavior, although he did roll his eyes once. I think everybody, the defense, I think, had reason to regret his having put him on, so they weren't eager to extend things much on redirect. And the prosecution did, I would say, probably 30 to 45 minutes more of cross that was mostly aimed at embarrassing the witness over his emails with Michael Cohen. It was an extremely sarcastic cross that I will let others describe. But he got off the stand without further incident, is I guess the best you can say for it. Um, uh, Anna or Quinta or Tyler pick up with the nature of the cross, but I thought the defense was frankly lucky to escape with the minimal additional damage that happened today.
Well, I think it might also be useful to clarify just exactly what happened yesterday, because when we had recorded, we didn't yet have the transcript from what happened when the press was kicked out of the courtroom. So the transcript was released, and it turns out Merchan essentially appears to have turned to Costello and said, if you don't knock this off, I'm going to hold you in contempt. So that threat appears to have worked. As Ben said, he was much better behaved, but there was a lot of hidden and not so hidden sarcasm in terms of his interactions with Hoffinger. So he yesterday had responded to some of her questions about, what did you mean in this email, and so on and so forth, by saying the email speaks for itself. And so there were multiple points where she asked him, does this email speak for itself? Does this email speak for itself? And he did not take well to that, I would say. He seemed sort of put out, but he certainly wasn't as explosive as he was yesterday. Tyler and Anna, is that fair?
Yeah, I think that that's fair. I mean, keep in mind, I think one of the main reasons that the defense put Costello up there on the stand as one of their witnesses is so that he can testify that, yeah, in 2018, I had all these conversations with Michael Cohen. We developed a relationship. He wanted to say that it was an attorney-client relationship, but Cohen disputes that. But then the key thing that goes to the substance of the defense here is that Costello testified on direct that Michael Cohen told him in 2018 he had nothing on Donald Trump and that Trump didn't know anything about the Stormy Daniels payment. So those are the really key substantive points the defense wanted to get out. And then what the defense was, or excuse me, what the prosecution was trying to do on cross-examination was impeach Robert Costello with his own words. And it was incredibly effective and meticulous in my view, because as Quinta noted, the prosecutor, Susan Hoffinger, went through with all of these emails that went to this idea that it was trying to explain why Cohen back in 2018 would have told Costello, oh, I've got nothing on Trump, and he didn't know, because Cohen's explanation is that he was still trying to be loyal to Trump because there was this pressure campaign that was going on in which Costello with Rudy Giuliani and Trump were trying to, pressure Cohen to stay in the fold, to stay with the Trump camp. That's how Michael Cohen described it. And so in order to kind of show this, Susan Hoffinger was going through all of these emails, some of the ones that I think, were already public, but a lot of people maybe rediscovered them today. One of which was Costello writing to his law partner, in which that he said something to the effect of, our issue is that we need to make it make Michael think that we're keeping him satisfied, while not letting on that we're taking instructions from Trump or Giuliani. Did I get that right? Is that the basic essence of it? Yeah.
Mm-hmm.
Yes. And so there's all of these other ones, they once again walked through in painstaking detail these other emails that kind of suggest a pressure campaign in which Costello's talking about a back channel to Rudy Giuliani and up to Trump. There's all these weird code words about, I talked to my friend, wink, wink, who has a meeting at the White House and he can communicate things for you. Sleep well tonight. You have friends in high places. And Susan Hoffinger manager got Costello to say, yeah, that definitely does refer to Trump, the friends in high places thing. So I thought it was really effective. And I thought that the sarcasm actually was effective as well. And so it was an overall good moment for the prosecution and really bad note for the defense to end on, I think.
Yeah, one thing though that I keep wondering about the Costello testimony is whether it matters at all. He was called to kind of rebut Michael Cohen on a very marginal component of Michael Cohen's testimony, which is, this pressure campaign that has really nothing to do with whether documents were falsified within the Trump organization. And so I wonder if the jury is just going to kind of shrug off the question of whether Cohen is credible on this point or whether Costello is credible on this point, because at the end of the day, it doesn't really have very much to do with the body of the offense, which is, falsifying business records in the Trump organization to cover up a payoff for a reimbursement to Cohen for a payment to Stormy Daniels that happened a couple of years earlier. So I keep scratching my head and wondering somewhat the same question here that I wondered about Stormy Daniels' testimony, except in this case, it's not about the prosecution putting him on, it's about the defense putting him on, which is how exactly does this vindicate, even if everything Costello is saying is true, how exactly does it vindicate Trump on anything?
Yeah, and I think that's right, because it still is going to come down to the intent issues that we've talked about before, the causation issues. We'll get into that, but I think that you're right, Ben. And also the other thing that I don't think we mentioned yesterday that is worth keeping in mind here is that Costello already testified before the grand jury when Trump was indicted as a rebuttal witness of sorts, exactly in the same kind of role that he played here. Obviously, there's a very different standard at the grand jury level. It is simply, much lower than what it is here in terms of beyond reasonable doubt. So maybe there's a reason that the defense still thought that it was worth putting Costello up, even though it was clearly not effective at the grand jury phase. But it is just worth keeping in mind that clearly the grand jurors did not find his testimony to be either credible or persuasive as it goes to the elements of the offense that they needed to find probable cause to indict.
Absolutely. And as you mentioned, after Costello finished up his testimony, the defense rested.
It was awesome.
I know.
We broke at 10:30 and we had almost 4 hours off. And that was a luxury none of us has experienced in weeks. And I just want to thank the court for making that happen for all of us. We went out to brunch.
Wow. Love that. So I wanted to get your thoughts before moving on to the 215 hearing that you went back for. What are your thoughts on the defense's overall performance and their choice to have Trump not testify?
I mean, I don't think it's any surprise that he didn't testify, right? If I were Todd Blanchard, Emile Beauvais, or Susan Nicholas, I would have tackled him physically to the ground before allowing him to take the witness stand, just because the man cannot shut up. And especially if you put him under oath, I mean, bad things will happen. So I don't think it was any surprise, although certainly the defense, tried to keep people guessing for as long as possible about whether or not that might be a possibility.
Yeah, I was thinking about this very question of whether the defense is worse off now after having rested their case than before they began it. But I think I'm still a bit mixed on that, because I think to Ben's point with the relevance issue, I don't know if they'll be thinking much about the evidence that came in through Costello or his testimony with regard to the actual charges themselves. But he definitely didn't leave a good impression on on the jury, to say the least. But keep in mind that we adjourned today. We're hearing summations Tuesday. Deliberations probably won't start until Wednesday at the earliest. So some time will have passed. People will have a nice barbecue at Memorial Day. Maybe they've gotten the bad taste of Costello out of their mouth by then.
And also, Catherine, on your question about Trump not testifying, again, not surprising. We already knew too that there were other factors, like we knew he'd be able to be questioned from the Sandoval rulings about a number of things that probably the defense would not want their client to be questioned about beyond just the kind of substantive facts of this case. So things like the civil fraud trial, the E. Jean Carroll defamation, that kind of stuff that you just wouldn't want the jury to hear. But one thing that I am curious to hear people's opinions about is that clearly here a defendant has the right not to testify, and it's not supposed to be held against them. That is their right to against self-incrimination to not do so. It won't be an adverse inference. But here we have a person who is super high profile, has been out in the media saying, I'm going to testify. I want to testify. All of this stuff over and over and over again. Potentially that is something that's reached the jurors' ears that maybe they're aware of. And there are, of course, kind of psychological elements to being a juror in which, like, maybe you can't separate the fact that you've been told, okay, don't take into account the fact that he won't testify, but maybe sometimes it just is the case that jurors can't help but thinking about that as they're deliberating in maybe some unconscious or at least implicit way. So does anyone here think that that's a factor in any of this, or is that just something that this is, of course, just kind of irresponsible speculation? I have no idea if the jurors are thinking about that at all, but what do you guys think?
Anytime you put on a witness, and it's, by the way, your only substantive witness, who makes a bad impression, that's not a good thing. Now, does it matter much? We don't know. We'll never know, because the jurors aren't going to come out if they convict and say, I really wasn't going to convict until I heard from that Robert Costello guy, but he pissed me off so much that I figured Trump must be guilty of everything. But
I'm talking about the Trump's choice not to testify, and whether there might be some kind of implicit, or unconscious consideration that the jurors might be taking into account because he has been so vocal about the fact that he wants to testify.
Well, so, first of all, that would be lawless and a violation of Trump's Fifth Amendment rights. And
as I just said, yes.
And also, we should not assume like a juror is not going to come out and say that. At least I would hope not, because it would be grounds for appeal. I think you have to assume that jurors take their oath seriously and that they follow instructions until you have some reason to think otherwise.
So I want to get to that 2:15 hearing you mentioned. The jury is excused until next week. You have a nice brunch. Think about their Memorial Day plans, and then you're back in court at 2:15 for a charging conference. Briefly, what is a charging conference, and how did Justice Merchan's rulings here impact the case against Trump?
So a charging conference is a conference in which the parties come together before the judge and try to iron out any disputes between them about how the jury is going to be instructed. And in this case, Justice Merchan basically said to the parties, come up with anything you can agree on, send me a jury instruction on, and anything you can't agree on, let's flag differences, and then we'll go over them in the charging conference. And so this was, I guess, on each side. The first, Justice Merchan went through the joint submissions that they'd made, and there were, I don't know, 10 or 12 issues where they had flagged differences. And then Emile Bovy for the defense went through 6 or 8 defense proposals. And then Josh Steinglass went through 3 or 4 for the prosecution. So it was probably about a 2.5-hour hearing altogether. And it was hard to follow it because we didn't have any of the underlying documentation. But I think it is fair to say that the jury instructions that are going to emerge from it are much closer to what the prosecution would want in an ideal world than what the defense would want in an ideal world.
Yeah, I'm curious if that's. Oh, I'm curious, or Ben or Quinta or Anna's thoughts on whether you think the fact that they are going to come out closer to the prosecution's wishes are a matter of fairness, or was it because the defense's submissions were so egregious? Or from what we could tell, I mean, as Ben said, it was very difficult to follow for 2 reasons. One being that we couldn't actually follow anything. They would refer to the last 2 paragraphs, and we were, in there blind. And also, secondly, for a few of us, we were actually caught in between in the hallway while Trump was still giving his remarks. So we couldn't come in until it was already in medias res, and it was just like, like we're groping around in the dark. But yeah, that same question. I'm curious, your sense of what you got from Bovy's suggestions, whether they were outrageous, as Steinglass called one of them, or why we landed where we did, or probably will.
I will say, I think that, well, first up, I was talking with a reporter sitting next to me right after we broke for the day, who said that, it was kind of like listening to somebody edit an article, like narrate their edits to an article without actually having access to the article.
That's exactly what it was.
we're gonna move the apostrophe, we're gonna move the comma to the end of the line. What is he talking about? There's no way to know. And this is unusual. I think it's worth saying. I mean, I've never reported on a New York criminal trial before, but it seemed like there were frustrations from reporters who have. So that's, not something that I think any of us expected. We're kind of playing on extra hard mode. In terms of where the jury instructions came out, I mean, I think it was notable that often the suggestions from the defense that Merchan rejected were suggestions that Bovy was making that would have led the jury instructions to deviate from the New York criminal jury instructions, which is sort of the model, like the base text from which jury instructions are drawn. And so often, Bovy would say like, well, we want this edition for, such and such reason. And then Matthew Colangelo for the prosecution would sort of pop up and say, Judge, like there's a reason that we submitted it like this. It's because it was drawn from the criminal jury instructions. Those were written that way for a reason. And Merchan said, I don't have the quote in front of me, but something along the lines of, I'm not going to, these were put together by a bunch of very smart people, and I'm not going to deviate from them unless there's a good reason. And I'm willing to deviate from them if there's a good reason, but I'm not going to just go changing things willy-nilly. And so in that respect, I think there's an element of sort of small c temperamental conservatism in Merchan's approach, which is really consistent with his approach throughout the trial. But the defense was definitely, I think in most cases, although maybe not all, I mean, and definitely others tell me if you think I'm forgetting anything, because that was very confusing. The defense was taking most of the big swings rather than the prosecution.
Yeah, and that's not unusual. That it's usually the defense who is trying to come up with more like novel or generous instructions to fit the facts as they're charged against their client. And it's not that Justice Merchan was necessarily citing with the prosecution because he just thought they had really great arguments. I do think it was more of he was like, this is what the law is. This is kind of what the standard instructions say, as Quinta noted. But then there were also times when there were things that the prosecution tried to branch out a little bit, and he also went with the more standard instruction that had been suggested by the defense in that case. So, for example, on the causation issue, Trump, the prosecution has to prove beyond a reasonable doubt that Trump made or caused these false entries to be entered. And as a part of the instruction on the causation element of the crime, the prosecution wanted Mershon to instruct that, it was sufficient if it was whatever Trump did to cause those entries to be made, it was reasonably foreseeable that the entries would be made, so that reasonably foreseeable language is from a case that Mershon did not think was necessarily applicable here. Wasn't that language is not in the pattern jury instruction. And so he went with the more standard definition that is in these, standard instruction that's given. So again, I think he was pretty equal opportunity with his conservatism. And if the defense had come with the prosecution had come with the more novel arguments, I think he would have sided with the defense more.
Yeah, and just one, while it is hard to construct the overall picture from just the hearing without the documents, there is one very important thing that was very clear, which was that he very clearly ruled that as to the step-up offense, the jury does not need to be unanimous on which form of unlawful means the defendant may have used. There are three theories that the prosecution has put forward, and different jurors can pick different ones that they think are his intent to commit or obscure or conceal that crime was done by. And that's, again, seems very clear from the law, but is a big win for the prosecution. I think it makes a conviction much easier.
I think that's broadly right. I think there's one additional twist, which again, it's really hard to tell because we don't have the draft, so we don't know what we're talking about. It seems like they are settling on one of the specific object offenses, the New York election law conspiracy statute. And rather than saying, the jurors don't have to agree on which of the object offenses was used to step up the misdemeanor records falsification to a felony records falsification, they're saying there's this one New York election conspiracy charge that is the step up, but that election conspiracy charge depends on an unlawful means being used, and that there is not a requirement for jury unanimity as to which of the means, which of the three means were used. If that sounds confusing, it is. And I'm very sorry, but you can read something that Tyler and I have put together on Lawfare on the subject. I will say I thought it was very interesting that Bovee, while he was arguing for jury unanimity for a requirement, he said that it was not necessary under the law, which I thought was a notable statement from him because Tyler, in the article that we put together, there was some question about whether or not it actually would be required. Although granted, that had to do with thinking about unanimity on the object offense rather than on the unlawful means that would lead to one of the object offenses becoming an object offense in the first place.
There was also a quick addendum to that. Again, I believe this is what was happening, but there was also an argument I think the defense was making that they wanted to rule out some of the unlawful means that were civil charges, and Matthew Colangelo was making the argument that it says unlawful means, it doesn't say criminal means. They could have written criminal means if they meant criminal means, but just unlawful means a violation of the law, be it civil or criminal, which I thought was
Right.
pretty convincing.
And the judge did not rule on that question. He took it under advisement.
Right.
We will find out the answer to it when he issues his jury instructions, which he says he will try to do by the end of the day on Thursday.
And just to be clear, the relevance of that is that specifically this has to do with a federal campaign finance violation. So AMI, this can't be used for evidence of Trump's guilt, but it is relevant for the underlying fact pattern. AMI reached a conciliation agreement with the FEC as to a civil violation of federal campaign finance law. So limiting that to a criminal means sort of makes it a little more complicated for the although not necessarily hugely more complicated for the jury to find that that was an object offense.
To be determined. Sorry, Anna, go ahead.
Oh yeah, no, I was gonna say there was also, in addition to just kind of instructions on the actual law, there were also limiting instruction. Again, we don't yet have access to these filings, but I thought was a really interesting moment that might be worth noting is that the instruction on basically an adverse, being able to draw an adverse inference against Michael Cohen about potential evidence that might have been destroyed or deleted on his phones. And there was this moment in which Justice Merchan was very complimentary of Emil Bovee and said, I think that you did a really great job of this cross-examination of the witness with the, phone records. You've laid a lot of really good foundation for this, and you can definitely argue it in closing. However, it's not going to be an instruction that I will give, but it was just very interesting to see Justice Merchan that openly complimentary of Emil Bovee's cross-examination skills. So it looks like we're not the only ones who think that Emil Bovee is very skilled at cross-examination.
You really got to hand it to him.
And we'll leave it at that. Anna Bauer, Tyler McBrien, Quinta Jurecic, and Benjamin Wittes, thank you for joining us today. And thank you all for watching. If you want to support Lawfare's coverage of the Trump trials and watch this dispatch without ads, become a Lawfare Material supporter at lawfaremedia.com.